How you doing today? Today's topic is choosing the right attorney, which when you're getting involved in a custody suit, it's one of the most important things you can do. So we want to make sure you have all the information necessary to make an informed decision here, because it can make the difference between A, winning and losing, B, bankruptcy and non-bankruptcy. So anyway, how do you find the right attorney? Well, to begin your search for the right attorney, you can start by trying to find an attorney that specializes in family law, especially divorce, child custody cases. Now, designations to look for are the CFLS, which is Certified Family Law Specialist, or the AAML, which is the American Academy of Matrimonial Lawyers. Now, lawyers who are part of the AAML must be chosen by their peers. So this is kind of the Marines or the Jesuits of lawyers. These are the best of the best. Now, if you have a simple divorce and custody case, you may not need to go to that level, because these are also probably going to be the most expensive. But if you want the best, you definitely want to get the AAM lawyers. And for sure, you want to get a lawyer who's CFLS. And once again, that's Certified Family Law Specialist. You don't really want to go to a generalist on this. You know, if you're in a big city, it should be no problem. If you're in a small town, maybe there's less of a selection. But if possible, go for somebody in one of these categories. And once again, the AAML, I mean, these are the elite group of lawyers. They're the ones who are the top of their game. They have significant experience on large, complicated cases, but, you know, they're going to be more expensive. Now, while designations are significant, that's only part of picking the right lawyer for you. Experience and background are equally as important. Now, in interviewing prospective attorneys, find out how much of their practice is dedicated to family law and to child custody-related issues. Ask them what kind of track record they have for experience in similar cases. Ask their opinion of your case and what they believe is the likely outcome. Find out what kind of strategy they'll be using if they're retained. What are their strengths and what are their weaknesses? And also, in their opinion, what are your strengths and what are your weaknesses in terms of this case? Now, make sure you know what their plans are for reaching a settlement. And if a settlement is not possible, what's their trial experience? And what's their trial outcome record? So, in general, I'll say this right up front, you always want to settle. You never want this to go to trial. But if you're absolutely dealing with an ex who's a jerk, you may need to go to trial. So you need to find this out. But we are not in any way advocating someone who wants to go to trial. You want someone who's going to negotiate. You want someone who's going to compromise, because you want to get this done before you get to trial. Because think of it this way. At the end of the day, do you want to decide what's best for your kids, or do you want the court to do it? Chances are you're going to do a better job than the court, almost certainly. And they don't want to make that decision. They want you to decide. But having said that, you still need a good attorney. Now, ideally, and this one also is key, not always possible, you want a lawyer that has experience dealing with your judge. So if you're pulling a lawyer from another city who's never worked with that judge, that's a really bad idea. If your lawyer knows, and more importantly, has rapport with the judge, that can make all the difference. It's going to save you time, it's going to save you money, and that's a big advantage. During my divorce, my ex's lawyer didn't know the judge, and she used a tactic that completely backfired. The court changed judges in the middle of the case, and her attorney, without knowing the new judge, tried to dramatically make the case that I was the one dragging out the case and needlessly running up legal bills. She actually wheeled in a cart with 12 banker's boxes of legal documents related to the case, thinking that was going to put me in a bad light. The judge saw this and shouted, "This stops now." Needless to say, her theatrics didn't help. In fact, it hurt her case because this attorney didn't know the judge and she had no idea that this type of tactic was going to completely backfire. Anyway, Another question you should ask when interviewing attorneys is, do they have experience dealing with opposing counsel? If so, ask them about their experience with them. If they never worked with opposing counsel, they should at least become familiar with their track record and their tactics, because that's who they're going to be up against. Now, aside from gathering information on the prospective attorney's background, reputation, and track record for settling cases, you should also take into consideration their attitudes and their styles. Some lawyers assume you will BK, file bankruptcy, before it's over, especially if they see a high degree of conflict and a lack of willingness to compromise. They may demand large retainers, and instead of trying to diffuse the tension and negotiate a compromise, they might fan the flames of anger and resentment. Don't worry, we won't let them get away with that. Now, it's best to avoid this type of lawyer if you want to emerge financially solvent with a reasonable settlement. Also, if they believe you're going to be forced into bankruptcy, it may influence how they try the case. Because once your funds run out, their effort they put forth is going to decrease, if not cease completely. Now, attorneys can and do fire their clients. And while it's not in the attorney's, it is in the attorney's best interest to win the case, your financial position may have a direct relationship on the strategy that they're going to use. See, attorneys have an inherent conflict of interest. While on the one hand they want to win, on the other hand, they may be pressured by their firm to bill as much as possible. So they're not necessarily trying to win as quickly or as cheaply as possible. So it doesn't always involve compromising the way it should. So you really have to evaluate your attorney and their firm in terms of, do they want to negotiate? Are they just in this for the money? Do they truly care about my best interest, or they just don't care if we run up bills forever because they're getting paid more? Now, you're better off choosing an attorney who's good at negotiating and settling, as this is going to decrease your, it's going to increase your chances of coming up with a favorable settlement, and it's going to decrease your chances of filing bankruptcy. Even if opposing counsel is overly aggressive. And while it's not always possible, it's better to avoid going to trial. In fact, most courts require mandatory settlement conferences with mediators to save the court time and save you money, to see if you can work things out amongst yourselves with an impartial, neutral mediator. Now, of course, this is the best way to go, but if the other parent is unreasonable, this may not work. It doesn't always, but it's definitely worth a try. Once again, ask yourself, is this worth fighting over? These are the kind of questions you want to always have in your mind. Is it worth my child going to therapy because we're going to fight over the couch, or because she had an affair and I'm so pissed I want to get back at her at any cost? So always keep the best interest of the kids absolute first and foremost in your mind. Is it worth ruining their lives because you're angry? And secondly, how much is that couch worth in terms of your financial solvency for the future? Are you willing to file bankruptcy? Are you willing to spend an extra $25,000 fighting over a $2,000 couch? I mean, it's easy to lose sight of this in the heat of the battle. So before you get started, it's good to get in that mindset and say, you know what? It's better to let all the material things go, not fight. It'll be better for my kids. And you know what? Long term, it's going to be better for me. So if you can, absolutely positively want to negotiate and you want to settle this before going to trial. In the end, a divorce is about dividing up families and assets in a reasonable and hopefully a fair manner. In other words, it is about compromise. Divorcing parents rarely get everything they want, and most divorcing parents feel like they were raked over the coals by their lawyer, the court, and the other parent. The longer the divorce and custody drags on, the worse it gets. The judge wants you to get through the process as quickly and fairly as practical. If the judge perceives you're being unreasonable or dragging your feet, it's going to reduce your chances for a good settlement, and it's going to increase your legal fees. I've said this before, I'll say it again. Do you want to use your savings to send your kids to college or to send your lawyer's kids to college? Think about it. Now, the best attorney will help you move through the process at a reasonable pace and in the end feel like you've reached an equitable compromise or settlement. Once again, you're not going to get everything you want. No one ever does. But you want it to be reasonable. You want it to be fair. Choosing the wrong attorney is always going to cost you more. Not just financially, but emotionally, how you feel about the settlement, and how your children fare afterwards. Now, while it's important to find the right lawyer, it may be even more important to avoid the wrong lawyer. If you're unreasonable in the eyes of the court, even if it's on the advice of the lawyer, then it's going to end up costing you in a variety of ways. You should view your lawyer as a very expensive and highly paid employee. If they're not doing their job properly, it can substantially increase your legal costs. So you need to choose a lawyer carefully. Do not be afraid to fire your lawyer. You may not understand law, but you should have a good idea of the strategy, what's happening in the case. You shouldn't second guess your lawyer on the details, but on the big overall strategy, you may want to make sure that you're on the same page, because if you're not, chances are you're not going to enjoy what happens. So make a realistic effort to educate yourself, at least about the basic understanding of how family law works with respect to custody. It's not rocket science. Don't use your lawyer as a therapist or for emotional relief. It will prove to be a very expensive misallocation of resources. And that's one reason to have a custody coach who's not an attorney. So, and just to give you a little advice here, attorneys know law. Attorneys don't know children. And attorneys don't know custody particularly well. One of the biggest things, I talked about this in another section, but I can't say it enough. When you get into a custody battle, and when you're paying a lawyer, probably 80% of what you're paying them for is administrative tasks, like writing up declarations, writing income and expense statements, writing asset statements. You don't need to pay them to do that. You don't need to pay them to write a custody plan, okay, or a parenting plan, or a custody timeshare. You should think about doing all this yourself. Let them have the final say, let them have the final write-up, but they don't need to waste emotional brain power on this. They should be focused on the law and winning the case, not doing the administrative things. Now, let's talk about running up legal fees. A really bad attitude to have, and I've seen it many times, is I don't care how much it costs, I want them to suffer for what they did. Parents, divorcing adults are angry at each other usually. And if you let that emotion get in the way, it's going to get very expensive and everyone's going to be happy at the end. So when you hear that, I don't care how much it costs, I want them to suffer, or God forbid you utter those words, other than to delight your attorney about how much they're going to make from you, the statement demonstrates the wrong attitude and it's going to get you in trouble as well as cost you. I am the mother, so I deserve the bulk of the custodial time. He makes more than I do, so he's going to be paying my legal bills. So I'm going to accuse him of everything under the sun. The legal firm of this is yours and that is mine loves to hear statements like that. Many fathers also initiate expensive battles to become the primary custodial parent in an effort to reduce support payments. Unfortunately, many mothers use increased support as their motivation for not agreeing to joint custody as well. Now, in most states, like California especially, it's easy to take this tact as support is based on the amount of custodial time you have with the child. But this is a mistake. I knew a dad who wanted to be the primary custodial parent, even though he wasn't available during the week, and living in his girlfriend's trailer with her kids, just to minimize support payments. Well, not surprisingly, the judge didn't agree. Some states may also make you responsible for paying the other parent's legal fees, not only based on your ability to pay, but also if they feel you're unnecessarily running up the cost of litigation. And this is true even if you're only following the advice of your attorney. During my divorce, my ex outspent me on litigation 4-1, and I earned double what she made. But in the end, I was only required to pay a fraction of her attorney's fees, despite their ongoing request to have me pay 100% of it. And this is because I always tried to negotiate and compromise. My lawyer told me, and I listened, be sensible, take the high road, try to minimize your legal expenses. And when it's over, you're going to be very glad you did. So that's our section on choosing the right attorney. As always, if you have any questions, feel free to write me, joe@platinummmethodcoaching.com. Until then, have a great day.